Chapter 3, Frauds and Illegal Exactions and Transactions. Article 213. Frauds against the public treasury and similar offenses. Acts punishable as frauds against public treasury and illegal exactions. 1. Entering into an agreement with any interested party or speculator or making use of any other scheme to defraud the government in dealing with persons with regard to furnishing supplies, making contracts, or the adjustment or settlement of accounts relating to public property or funds. 2. Demanding, directly or indirectly, the payment of sums different from or larger than those authorized by law, in the collection of taxes, licenses, fees, and other imposts. 3. Failing to voluntarily issue a receipt for any sum collected officially by him in the collection of taxes, licenses, fees, and other imposts. 4. Collecting or receiving, directly or indirectly, by way of payment or otherwise, things or objects of a nature different from that provided by law, in the collection of taxes, licenses, fees, and other imposts. Elements of frauds against public treasury. Paragraph 1. 1. Offender is a public officer. 2. He has taken advantage of his office. 3. He entered into agreement with any interested party or speculator or made use of any other scheme with regard to 1. Furnishing supplies. 2. The making of contracts. 3. The adjustment or settlement of accounts relating to public property or funds. 4. Accused had intent to defraud the government. Note: public officer must act in his official capacity. Crime of frauds against public treasury is consummated by merely entering into an agreement with any interested party or speculator or by merely making use of any other scheme to defraud the government. Elements of illegal exactions. 1. Offender is a public officer entrusted with the collection of taxes, licenses, fees, and other imposts. 2. Guilty any of the following acts or omissions: A. Demanding directly or indirectly the payment of sums different from or larger than those authorized by law. Or B. Failing voluntarily to issue receipt for any sum of money collected by him officially. Or C. Collecting or receiving, directly or indirectly, by way of payment or otherwise, things or objects of a nature different from that provided by law. Notes: mere demand for larger or different amount is sufficient to consummate the crime. When there is deceit in demanding greater fees than those prescribed by law, the crime committed is estifa and not illegal exaction. Article 214. Other frauds. Elements. 1. Offender is a public officer. 2. He takes advantage of his official position. 3. He commits any of the frauds or deceits enumerated in Articles 315 to 318. Notes: the RPC has jurisdiction when this article is involved. Article 215. Prohibited transactions. Elements. 1. Offender is an appointive public officer. 2. He becomes interested, directly or indirectly, in any transaction of exchange or speculation. 3. The transaction takes place within the territory subject to his jurisdiction. 4. He becomes interested in the transaction during his incumbency. Notes: the transaction must be one of exchange or speculation. Purchasing of stocks or shares in a company is simply an investment and is not a violation of the article. But buying regularly securities for resale is speculation. The appointive public officer should not devote himself to commerce. Article 216. Possession of prohibited interest by a public officer. Persons liable for possession of prohibited interest. 1. Public officer who, directly or indirectly, became interested in any contract or business in which it was his official duty to intervene. 2. Experts, arbitrators, and private accountants who, in like manner, took part in any contract or transaction connected with the estate or property in the appraisal, distribution or adjudication of which they had acted. 3. Guardians and executors with respect to the property belonging to their wards or the estate. Notes: actual fraud is not necessary. The act is punished because of the possibility that fraud may be committed or that the officer may place his own interest above that of the government or party which he represents. Intervention must be by virtue of public office held. Chapter 4. Malversation of public funds or property. Article 217. Malversation of public funds or property. Presumption of malversation. Acts punishable in malversation. 1. Appropriating public funds or property. 2. Taking or misappropriating the same. 3. Consenting, or through abandonment or negligence, permitting any other person to take such public funds or property. 4. By being otherwise guilty of the misappropriation or malversation of such funds or property. Notes: malversation is otherwise called embezzlement. Penalty for malversation is the same whether committed with malice or through negligence or imprudence. Elements common to all acts of malversation under Article 217. 1. Offender be a public officer. 2. He had custody or control of funds or property by reason of the duties of his office. 3. He is accountable for said public funds or property. 4. He appropriated, took, misappropriated or consented, or through abandonment or negligence, permitted another person to take them. Notes: the nature of the duties of the public officer, and not the name of the office, is controlling. An accountable officer is one who has custody or control of public property by reason of the duties of his office. Funds or property must be received in official capacity. When a public officer had no authority to receive the money for the government and upon receipt of the same, he misappropriated it, the crime committed is estifa, not malversation. A public officer having only a qualified charge of government property without authority to part with its physical possession cannot be held liable for malversation. Private individuals liable for malversation under Article 222. Private property may be involved in malversation as long as such funds or property are placed in the custody of said public officers. To sustain a charge of malversation, there must either be criminal intent or criminal negligence. And while the prevailing facts of the case may not show that deceit attended the commission of the offense, it will not preclude the reception of evidence to prove the existence of negligence, because both are equally punishable under Article 217. If malversation is not committed through negligence, lack of criminal intent or good faith is a defense. Presumption of malversation: failure of a public officer to have duly forthcoming any public funds or property with which he is chargeable, upon demand by any duly authorized officer, shall be prima facie evidence that he has put such missing funds or property to personal uses. The presumption may be rebutted. Prima facie presumption does not arise if the fact that the funds are missing is not clearly established. Payment or reimbursement is not a defense, but may be considered a mitigating circumstance. Damage is not an element of malversation. Demand is not necessary in malversation. Damage to the government is not necessary. Article 218. Failure of accountable officer to render accounts. Elements: 1. Offender is a public officer, whether in the service or separated therefrom. 2. He must be an accountable officer for public funds or property. 3. He is required by law to render accounts to the Commission on Audit, or to a provincial auditor. 4. He fails to do so for a period of 2 months after such accounts should be rendered. Notes: demand for accounting is not necessary. Return of unliquidated funds is only a mitigating circumstance. Misappropriation is not necessary. Note: RA 10175, an act defining cybercrime, providing for the prevention, investigation, suppression and the imposition of penalties therefor and for other purposes. Section 4 Cybercrime Offenses. The following acts constitute the offense of cybercrime punishable under this Act. A. Offenses against the confidentiality, integrity and availability of computer data and systems. Article 219. Failure of a responsible public officer to render accounts before leaving the country. Elements. 1. Offender is a public officer. 2. Accountable officer for public funds or property. 3. He unlawfully left the Philippines without securing from the Commission on Audit a certificate showing that his accounts have been finally settled. Article 220. Illegal use of public funds or property. Elements. 1. Offender is a public officer. 2. There is a public fund or property under his administration. 3. Public fund or property has been appropriated by law or ordinance. 4. He applies the same to a public use other than that for which such fund or property has been appropriated by law or ordinance. Notes. There is no technical malversation if there is no law or ordinance appropriating public funds or property for a particular purpose. Criminal intent is not an element of technical malversation. The offense is mala prohibita. In illegal use of public funds or property, the offender does not derive personal gain or profit, and said fund or property ID applied for public use. In malversation, the offender in certain cases profits from the proceeds of the crime, and the public fund or property is applied to personal use and benefit of the offender or another person. Technical malversation is not included in, nor does it necessarily include the crime of malversation of public funds. Article 221. Failure to make delivery of public funds or property. Acts punishable. 1. Failing to make payment by a public officer who is under obligation to make such payment from government funds in his possession. 2. Refusing to make delivery by a public officer who has been ordered by competent authority to deliver any property in his custody or under his administration. Elements of failure to make payment. 1. Public officer has government funds in his possession. 2. He is under obligation to make payment from such funds. 3. He fails to make the payment maliciously. Note: refusal to make delivery of property must be malicious. Article 222. Officers included in the preceding provisions. Private individuals who may be liable under Articles 217 to 221. 1. Private individuals who, in any capacity whatever, have charge of any national, provincial or municipal funds, revenue, or property. 2. Administrator or depository of funds or property attached, seized or deposited by public authority, even if such property belongs to a private individual. Purpose of Article 222, to extend the provisions of the Code on Malversation to private individuals. Notes: judicial administrator is not covered by this article. Private property is included, provided it is 1. Attached, 2. Seized, or 3. Deposited by public authority. Private individual under Article 222 is not deemed a public officer. Sandiganbayan has no jurisdiction over a private individual if the individual is not charged as co-principal, accomplice, or accessory to a public officer. Chapter 5. Infidelity of public officers. Section 1. Infidelity in the custody of prisoners. Section 44 and 49. Republic Act No. 9372. An act to secure the state and protect our people from terrorism. Section 44. Infidelity in the custody of detained persons. Any public officer who has direct custody of a detained person or under the provisions of this act and who by his deliberate act, misconduct, or inexcusable negligence causes or allows the escape of such detained person shall be guilty of an offense and shall suffer the penalty of 12 years and 1 day to 20 years of imprisonment. If the detained person has already been convicted and sentenced in a final judgment of a competent court and be 6 years and 1 day to 12 years of imprisonment. If the detained person has not been convicted and sentenced in a final judgment of a competent court. Section 49. Prosecution under this act shall be a bar to another prosecution under the revised penal code. When a person has been prosecuted under a provision of this act, upon a valid complaint or information or other formal charge sufficient in form or substance to sustain a conviction and after the accused had pleaded to the charge, the acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for any offense or felony which is necessarily included on the offense charged under this act. Article 223. Conniving with or consenting to evasion. Elements. 1. Offender is a public officer. 2. He is in custody or charge of a prisoner, either detention prisoner or prisoner by final judgment. 3. Prisoner escaped from his custody. 4. He was in connivance with the prisoner in the latter's escape. Note: if the public officer charged with the duty of guarding him does not connive with the fugitive, then he has not violated the law and is not guilty of the crime. Classes of prisoners involved. 1. Fugitive sentenced by final judgment to any penalty. 2. Fugitive held as detention prisoner for any crime or violation of law or municipal ordinance. Note: a detention prisoner is a person in legal custody, arrested for, and charged with, some crime or public offense. Note: release of a detention prisoner who could not be delivered to the judicial authority within the time fixed by law is not infidelity in the custody of prisoner. Note: leniency or laxity is not infidelity. Note: relaxation of imprisonment is considered infidelity. There is real and actual evasion of service of a sentence when the custodian permits the prisoner to obtain a relaxation of his imprisonment and to escape the punishment of being deprived of his liberty, thus making the penalty ineffectual, although the convict may not have fled. Article 224. Evasion through negligence. Elements. 1. Offender is a public officer. 2. He is charged with the conveyance or custody of a prisoner, either detention prisoner or prisoner by final judgment. 3. Prisoner escapes through his negligence. Note: what is punished in evasion through negligence is such a definite laxity as all but amounts to deliberate non-performance of duty on part of the guard. Note: there is only one penalty in Article 224. Note: the fact that the public officer recaptured the prisoner who had escaped from his custody does not afford complete exculpation. Liability of escaping prisoner. 1. Liable for evasion of the service of the sentence under Article 157 if fugitive is serving sentence of final judgment. 2. Does not incur criminal liability if he is only a detention prisoner. Article 225. Escape of prisoner under the custody if a person not a public officer. Elements. 1. Offender is a private person. 2. Conveyance or custody if a prisoner or person under arrest is confided to him. 3. Prisoner or person under arrest escapes. 4. Offender consents to the escape of the prisoner or person under arrest, or that the escape takes place through his negligence. Note: Article 225 is not applicable if a private person was the one who made the arrest and he consented to the escape of the person he arrested. Section 2. Infidelity in the custody of documents. Article 226. Removal, concealment or destruction of documents. Elements. 1. Offender is a public officer. 2. He abstracts, destroys, or conceals documents or papers. 3. Said documents or papers have been entrusted to such public officer by reason of his office. 4. Damage, whether serious or not, to a third party or to the public interest should have been caused. Note: if any of these circumstances is not present, the crime disappears, or rather, does not arise. Note: the document must be complete and one by which a right could be established or an obligation could be extinguished. Note: books, periodicals, pamphlets, etc., are not documents. Note: the word papers include checks, promissory notes, and paper money. Note: post office official who retain the mail without forwarding the letters to their destination is guilty of infidelity in the custody of papers. Note: a postmaster is guilty of malversation if he received money orders, signed signatures of the payees thereon, collected and appropriated the respective amounts. He is guilty of infidelity in the custody of papers if he receives letters or envelopes containing money orders for transmission, and the money orders are not sent to addressees, the postmaster cashing the same for his own benefit. Note: in addition to the actual injury done to the owner, the uncertainty as to the safety of such letters arising from thefts of their contents amounts to a real and positive injury to the postal service and hence to the public interests. Acts punishable in infidelity in the custody of documents: 1. By removing or 2. By destroying, or 3. By concealing documents or papers officially entrusted to the offending public officer. Note: not necessary that the act of removal must be coupled with proof of intention to conceal. Accordingly, removal, destruction, and concealment must be viewed as distinct modes of committing the offense. Note: removal must be for illicit purpose. Note: where the act of removal is actuated with lawful or commendable motives, as when documents are moved from their usual place to secure them from imminent danger of loss or destruction, there would be no crime committed. The removal is for an illicit purpose when the intention of the offender is A. to tamper with it, or B. to profit by it, or C. to commit an act constituting a breach of trust in the official care thereof. Note: crime of removal of public document and breach of official trust is consummated upon its removal or secreting away from its usual place in the office and after the offender had gone out and locked the door, it being immaterial whether he has or has not actually accomplished the illicit purpose for which he removed said document. Note: infidelity in the custody of document by destroying or concealing it does not require proof of illicit purpose, as offender could not have good motive. Note: delivering document to the wrong party is infidelity in the custody thereof. Note: damage in this article may consist in mere alarm to the public or in the alienation of its confidence in any branch of the government service. Article 227. Officer breaking seal. Elements: 1. Offender is a public officer. 2. He is charged with the custody of papers or property. 3. These papers or property are sealed by proper authority. 4. He breaks the seals or permits them to be broken. Note: crime is committed by breaking or permitting seals to be broken. Note: damage or intent to cause damage is not necessary. Article 228. Opening of closed documents. Elements: 1. Offender is a public officer. 2. Any closed papers, documents, or objects are entrusted to his custody. 3. He opens or permits to be opened said closed papers, documents, or objects. 4. He does not have proper authority. Note: custody means a guarding or keeping safe. Care? Note: offense is the breaking of seal, and not the crime of opening a closed document. because the offender must be a public officer not included in the provisions of the next preceding article. Note: damage or intent to cause damage is not an element of the offense. Section 3. Revelation of secrets. Article 229 Revelation of secrets by an officer. Acts punishable as revelation of secrets by an officer. 1. Revealing any secrets known to the offending public officer by reason of his official capacity. 2. Delivering wrongfully papers or copies of papers of which he may have charge and which should not be published. Elements of the first punishable act. 1. Offender is a public officer. 2. He knows of a secret by reason of his official capacity. 3. He reveals such secret without authority or justifiable reasons. 4. Damage, great or small, be caused to the public interest. Note: secrets must affect public interest. If not, revelation would constitute no crime at all. Note: espionage is not contemplated in this article. Article punishes minor official betrayals, infidelities of little consequence, affecting usually the administration of justice, executive or official duties, or the general interest of the public order. Note: secrets of private persons not included. Elements of the second punishable act. 1. Offender is a public officer. 2. He has charge of papers. 3. Those papers should not be published. 4. He delivers those papers or copies thereof to a third person. 5. Delivery is wrongful. 6. Damage be caused to public interest. Note: charge means control or custody. If public officer is merely entrusted with the papers but not with the custody of the papers, he is not liable under this provision. Note: if papers do not contain secrets, their removal for an illicit purpose is infidelity in the custody of documents. Note: higher penalty, if the act shall have serious damage to the public interest. Otherwise, a lesser penalty is imposed. Note: material damage to third person is not necessary. Note: RA 9372, an act to secure the state and protect our people from terrorism. Section 46, penalty for unauthorized revelation of classified materials. 10 years and 1 day to 12 years of imprisonment shall be imposed upon any person, police or law enforcement agent, judicial officer or civil servant, who not being authorized by the Court of Appeals to do so, reveals in any manner or form any classified information under this act. Article 230, public officer revealing secrets of private individual. Elements. 1. Offender is a public officer. 2. He knows of the secrets of a private individual by reason of his office. 3. He reveals such secrets without authority or justifiable reason. Note: revelation to one person is sufficient, for public revelation is not required. Note: when the offender is an attorney at law or a solicitor, Article 230 is not applicable. He is liable under Article 209. Note: damage to private individuals not necessary. Reason for this provision is to uphold faith and trust in public service. Note: RA 10173 or the Data Privacy Act protects individuals from unauthorized processing of personal information that is 1. Private, not publicly available, and 2. Identifiable, where the identity of the individual is apparent either through direct attribution or one put together with other available information.